So welcome everyone to week 5. It's now week 5 and we're quite close to the Christmas break. And of course, in the meantime, you're quite busy working on your midterm assessment. And one of the questions in the midterm assessment actually involves the week 5 question on unauthorized decision making. So it can be pretty helpful for us to really dig deep into this particular topic. It's a very important topic, mainly because it can get confusing because on the one hand, we know, as we said, that the executive has certain implied and even express powers. So the express powers of the executive would be based on the Constitution, particularly Section 61. And yet there are certain states, and when I say states, I'm talking of countries such as the UK or New Zealand, where they don't have a written constitution. And so therefore, if there is no written constitution that then provides express authority to the executive to undertake certain powers, then we wonder what is the source of the powers of the executive in those places, especially because the common law system of Australia is closely tied to that of the UK, and as well as New Zealand. And so in those countries, for example, or in international law, we call them states. In those countries, what would be the source of the power of the executive? Now, we will as well recall that, in the UK, for example, it was the monarch who had full powers. And not only did the monarch have the power to execute the laws, it was actually the law himself, until, there was a struggle between the monarchy in the UK as well as the parliament in the UK. And there came a point where sometimes it would appear that you need an authorization from the parliament for the executive to act in a particular way. So we wonder, when do we need, positive law? When does the executive need authorization from the parliament in order to be authorized to make decisions or act in a particular way? And that will be the focus of our discussion tonight. We will examine those instances when the executive is authorized to make decisions, even in the absence of any statutory authority coming from the Commonwealth Parliament. And at the same time, we will examine those instances when the executive can actually act on its own, like, if the executive decides to implement a program that will require a certain budget, and there is an absence of authorization from the parliament, would the executive be allowed to do that, especially if the purpose is really to disburse funds and fund certain projects? And the other related question is, what if there is in fact authorization coming from the Commonwealth Parliament? Let's say, if you, for some of us who grew up in the time of James Bond, 007, you would often hear instances when the spies or James Bond seems to have an authority to shoot on sight, permit to kill somebody, coming from the Commonwealth Parliament or even from the Queen. So what if the Commonwealth Parliament passes a law that just enables maybe a certain secretive group in the military to execute, and meaning kill people on reasonable suspicion that that person may be involved in domestic terrorism or international terrorism? What if the Commonwealth Parliament will pass a law that would authorize ACs, for example, to arrest maybe suspected terrorists, for a period of, let's say, 1 year? Or what if the Commonwealth Parliament would authorize torture, or even waterboarding, which the United States did for quite a while after 9/11? So what if there is an authorization coming from the Parliament? Would that mean, therefore, that the executive would have full authority to do what it wants, especially including committing torture, because of the laws passed by the Commonwealth Parliament? Or even then, you can even ask, what if the Commonwealth Parliament passes a law where there is a minister for communications with the power to actually shut down news outlets that might be publishing news stories or maybe fake news, and which could be harmful to the operations of the government? Would the decisions, therefore, of the executive, based on an authorization coming from the Commonwealth Parliament by statute, would that mean that the executive would, in fact, have the full freedom to do what it wants based on parliamentary authority? So that will be the topic of tonight's discussion. And after studying this topic, you should be able to discuss and explain whether legal authority is required for every executive decision or action to be made. You'll also be able to discuss and explain unauthorized decision-making and the types of executive decisions and actions that do not require specific legal authority. Now, before I continue, let me pause for a while. I'd like to know if you might have any questions or comments, which could be about, I don't know, the midterm assessment even. Questions, comments?
Yeah, I've got a question. I just can't find it. I was just literally looking for a pen.
Sorry, was it you, Michael?
Yeah, me. Yeah. Where is it located?
Which one are you asking about? The midterm assessment? Michael, I'm sorry, I kind of missed your question. What was the question there? Does anybody know what the question was? I didn't hear it quite well.
Yeah, Manjo, sorry. I think he was asking where he could find the midterm assessment. It is on Moodle, and it's also on your email. So if you click on your email, then it will actually take you to the Moodle site. Or if you go on the Moodle site, there is something that says midterm assessment just underneath the first part of your introduction, and click on that and it will bring the questions up.
Thank you. Thank you, Sarah. Okay, now we have a comment here from Lindsay, or a question. Please explain further. Parliament are elected by the people, the Queen is not, and holds no effective status within Australia. Torture is no longer legal within the Commonwealth. James Bond is a fictional character. Okay, Lindsay, which part would you like me to explain? The Queen is actually identified in the Constitution as part of the executive. And the Queen, under the Constitution, under Section 61 of the Australian Commonwealth Constitution, is represented by the Governor-General. And it is the Governor-General who exercises the powers of the executive under Section 61, but it is actually in behalf of the Queen. So the Queen of the UK, for example, is actually part of the structure of the Australian Commonwealth Government based on Section 61 of the Australian Commonwealth Constitution. Now, torture is no longer legal within the Commonwealth, but I was raising that question there. What if the Commonwealth Parliament actually passes a law to authorize torture? And so therefore, the Australian Federal Police, perhaps, the Australian military also use torture in order to elicit vital information in order to protect the national security interests of Australia. Would that be legal? Indeed, James Bond is a fictional character. I have no doubt about that. But we do know that torture happens even today. Where was this? I'm no longer sure if I was reading a newspaper. It was in the news, or was reading a novel, because I read a lot of novels which involve spy stuff. And what often happens actually is, in the case of the United States, what would then happen is that using the program known as rendition, they would actually kind of arrest somebody, detain the person. I would suppose it's illegal. They bring this person to a friendly country such as Saudi Arabia, where torture is a common practice and it would appear to be illegal. In those countries. And so while we know in Australia it's not permitted, so according to Travis, torture is subcontracted. It happens all the time. So it is happening. But there's that other aspect. How exactly do you define torture? Because torture isn't just, probably sticking electric prongs into the private parts of an individual. Torture can involve, making a person subjected to sleep deprivation for, let's say, 5 days or even 6 days in order to elicit a confession. Have you heard of those stories? There have been many instances in the past, even in Australia, where because of a person being deprived of sleep, that person will do anything just to be able to, be able to go to sleep. Yeah, right. Yeah, from Nadine. There was an airline involved in assisting U.S. with deportation for torture and so on. So, yeah, okay, very good. Now, Lindsay, I'm not really sure, what the question is here. Can you help me out? Which part would you like me to explain? Yeah, okay, indeed. Okay, yeah, not a very good reference. True, yeah. But when I read, sorry, what was that? What was it? Indeed, when I read spy novels, like there's an interesting fellow. His name is Daniel Silva, or it could be Vince Flynn. I wonder to what extent a lot of these stories are actually based on fact and which are really just pure fiction, because it would appear to me when I was reading on them, a lot of these things actually are based on facts, and they just change the the factual settings. Anyway, okay, the operation of the Commonwealth as opposed to the executive. So maybe I wonder if the point of the question was trying to kind of provide a bit of a background about the system of government in Australia. Would that be it? The executive, the parliament, and the judiciary. Was that the question, Lindsay? Okay, very good. So that's a good point, because hang on, I'm gonna mute everyone again. I'm getting some background noise there. This is a crucial point because unlike in other countries, such as the United States, for example, there is a clear delineation between the powers of the executive and the powers of the parliament or the Congress. In the U.S., they have the U.S. Senate, and they have the House of Representatives. And the executive really doesn't legislate, and the executive isn't part of Congress, or isn't part of the legislative body in the United States. But in Australia, following the Westminster system, such as in the UK as well as in New Zealand, it is different because, as we know, the Prime Minister and his cabinet are actually part of Parliament. And you wonder sometimes, is it the Parliament which is providing powers to the executive, or is it the Prime Minister and his cabinet who control the Parliament, which actually determine what national policies might be and what legislation should actually be passed that would then empower the executive? Because the Prime Minister and the cabinet decide what laws will end up being passed by the Commonwealth Parliament, assuming at that point that the Prime Minister and his cabinet have full control of both the Senate as well as the lower house. So there is a fusion in a sense of executive and parliamentary power under the Westminster system, because the Prime Minister and the cabinet are part of the legislature. And the third branch, of course, would be the judiciary, which has the power to interpret laws. So I think for now, that should be fine. Okay. So what we're going to do now is to look at 5 discussion questions in order to dig deeper into the question on unauthorized decision making. Would there be any other questions in the meantime? Yeah, Mary Moore raises a very relevant point, the torture of children in detention. And again, there are many aspects to torture because, in a sense, if you have parents being separated from the children being separated from the parents, wouldn't that amount to torture? So torture isn't just physical torture, it could be emotional torture. And so, yeah. So Lindsay would like to hear a response to Mary's point. Yeah, but really the problem there is how do you define, torture? What exactly is torture, and to what extent can you suggest that something that is being done would actually constitute torture and is therefore illegal, and what might be permissible. But in the meantime, I don't want to, drag this point further. We will revisit that point, I think, sometime in this tutorial, mainly because I do have a question about what constitutes purely a question of law, such as torture, which can be subject to judicial review, and when does something which is meant to be factual, when can it be considered to be subject to judicial review? Because we will recall that we had said that judicial review is limited to an examination of the law. It looks at legal questions. And the advantage of merits review is that not only does it look at a decision, whether or not it is according to the law, but it actually also examines the correctness of an executive decision based on facts. So that's the advantage of merits review. But there are instances when, you might have an instance when it has a mixture of the law and the facts. So a typical question might be involving torture. So when the executive, for example, decides that children, very young children, maybe the age of 3, who are both refugees, are separated from their parents in Manus Island, and there is a decision that, that action by the executive, by the Minister of Home Affairs, for example, is legal. Is that a factual question that can only be reviewed by the AAT, assuming that the AAT has been empowered to review decisions made by by the Minister for Home Affairs on the basis of the Immigration Act of 1967? Or is that a legal question as well? Can you see my point? So if there has been a decision by the Minister for Home Affairs, okay, who exercises his powers under the Migration Act of 1967 Commonwealth, that forces children below 7 years old, for example, to be separated from their parents in an immigration center for both refugees, and a decision is made on that point, does that involve purely a factual question, or is it a legal question as well? Let's just assume that, it doesn't really. Now, even the issue about national security, remember, even if it might involve a national security issue, ultimately it's still for the courts to decide the legality of what national security might be. And that brings me to that other point where, what if on the ground of national security, the Commonwealth Parliament allows torture, allows sleep deprivation, allows shoot to kill orders on the basis of reasonable suspicion? Would that mean that it is now beyond the pale of courts to make a determination as to the legality of those executive decisions? So that goes back to that basic question. And so therefore, I raise that other point where the Minister for Home Affairs might be empowered to, separate even an infant, maybe who is a month old, from a parent. And if a decision is made by the executive to do that, would that executive decision raise a legal question? Or is that a purely factual question because it seems to be done according to the law? And so we're going to look at that in a short while in this tutorial. Okay, now what we're going to do in the meantime is to examine this week's quiz. And if it's all right, can I ask someone to read quiz 4, the question for quiz 4, for us to just have a look at the principles behind this particular quiz. Can I get a volunteer to read the question?
I can do that, Manjo.
Thank you, Mike. Very good. Go ahead, please.
Okay, all right. Sherry Summers was suddenly awakened at a little past midnight by officers of the Australian Taxation Office, ATO, knocking on her door at home and informing her that they were seizing her computer, documents, and records relating to the operations and activities of the Summers WizKids Childcare Center, which she owned as a sole trader. The ATO officers informed her that they were acting under the authority and others of the Australian Commissioner of Taxation, the Commissioner, who had acted upon a detailed report that she was involved in tax fraud. The ATO officers explained to Summers that the Commissioner, although he was not authorized by the Income Tax Assessment Act 1997 Commonwealth or any other statute, had inherent non-statutory executive power to issue the orders when he has reasonable cause to believe that a tax fraud has been committed. Following this intrusion into her home and documents, Summers approached you, a solicitor, for advice. Do not read the Income Tax Assessment Act 1997, Commonwealth, or any other statute relating to the powers of the commissioner.
Thank you. And can you also read the choices, Mike?
Choices, yep. Okay, yep. All right. Which of the following statements is the most correct? A, the commissioner's orders are valid and legal as he has the inherent executive power, even in the absence of any statutory authority, to authorize his delegates to enter into any person's home in the event of tax fraud or a reasonable suspicion of tax fraud for the purpose of seizing any computer, documents, and records relating to the commission of the tax fraud. B, the commissioner's orders are valid since he was acting under the authority of the Income Tax Assessment Act 1997, Commonwealth. C, the commissioner's orders are invalid since under the principle of legality, any intrusion or violation of common law rights must be authorized by statute. D, the commissioner's orders are valid since under the principle of legality, the executive has the inherent non-statutory power to intrude or restrict common law rights. E, all of the answers are wrong.
Thank you. Thank you, Mike.
Thanks.
Can I just ask everyone to try to post his or her answer in the chat box, and we will take it from there. What do you think is the correct answer here? Very good. Okay. Okay. Okay, so everybody got the answer correctly. Very good. So that's the correct answer there. Let me just, we're going to go back to this in a short while, but I have another question, and we're going to go back to quiz 4, okay? But I have a question because it's a related point, and we're going to go back to the quiz, okay? I said already that you had the correct answer, which was, you know, letter C. But before we do that, let's just look at this particular discussion question because it is related to the quiz question. Can I again get somebody to read the question, to read this particular question for us? And then we will go back to the quiz question.
I can read this. I can read this one.
Thank you. Very good.
The Minister of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson, who was a law student at one time, asserts that the program is rubbish and has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorised. He seems to remember during his law student days that the minister is required by the principle of legality to have a statutory authority from Parliament in order to create a health awareness program. Manson has come to you as a solicitor. What would you advise him?
Very good. So again, here we have an instance of the executive acting on the basis of what he considers to be his implied executive power. So he's acting not on the basis of any statutory authorization, but on the basis of the exercise of his own executive powers in order to create this particular program. Without talking about standing for the moment, okay, without talking about standing, the legal standing of Manson for the moment, what do you suppose, is the minister authorized to actually create this particular program, or would he need statutory authorization in order to create this program? So yes, if you think he needs statutory authorization. No, if you think he doesn't need statutory authorization. Does he need it? Yes. Or is it no, meaning he needs statutory authorization? So some are saying yes, he needs it. Some are saying no, he doesn't. Okay. So essentially everyone is almost saying it's no. Why wouldn't he need statutory authorization for this?
Is it because it doesn't impinge on people's rights and freedoms, or is non-coercive? That's
right. So, Sarah, are you able to explain therefore to us the principle of legality? If you could.
Yeah, basically, the principle of legality is that in order for a government action to be lawful, it must be based on legal authority. But it then has been clarified in the sense that legal authority is only required if it impinges on direct rights and freedoms of individuals.
So legal authority in the sense of statutory authority, in the sense of an authority coming from the Parliament, would only be required when an executive action would impinge or interfere with common law rights and freedoms. But otherwise, if the executive is just making a decision or an action and it doesn't infringe on or impact upon the rights and freedoms of individuals, you do not need any statutory authorization for that, because we know that the executive possesses certain inherent powers, certain powers of the executive, both according to Section 61 of the Constitution and also by what are known as implied powers of the executive. So as Lauren correctly pointed out, Lauren Taylor said, the minister has decision-making authority in this instance as executive action, such as creating community assistance programs. Very good. So as Nicholas also pointed out, in Entick versus Carrington, it created an important distinction between those two sources of government power by effectively stating that the government's prerogative powers cannot be used as authorization in situations that interfere with fundamental rights of individuals. Very good. So we're clear. Now, having said that, therefore, so the advice to Manson would presumably be that the minister actually has the executive authority, both under Section 61 of the Constitution and these implied powers as an executive, to create this program. The only time when he would need an authorization from the Commonwealth Parliament in the form of a statute would be when his actions potentially would interfere with the rights and freedoms of individuals. So we're clear about that. Having said that, therefore, going back to the quiz 4, why, in this instance, the Australian Taxation Office Commissioner, the Commissioner for Taxation, had used inherent non-statutory executive power. Why would he need, why wouldn't he need statutory authorization, or why would he need statutory authorization in this instance? Why can't he rely on his inherent non-statutory executive power?
Because in this case, it actually infringes upon Sherry Summers' right of privacy in her own home and non-interference. So because he's going into a home and there's no express statutory power, he's using executive power, he needs authorization here from a statute. Very good.
And as pointed out by Damien, it is, individuals have a right to property. That has been, that's of a long-standing decision in the case of Entick versus Carrington. So anyone who steps on the grass of my lawn has already invaded my property. That is a right long recognized by the courts of England as far as the 1500s. Any questions so far? So we're good? Okay. Now, and let's go back to this discussion question, because this relates to what I had said earlier about the use of torture and whether or not, at what point can there be purely a factual question that is no longer subject to judicial review, and when can there be a point where a matter can actually be subject to judicial review, even if it seems to involve a question of fact. So an example of a question of fact would be an executive decision to deprive a person of sleep for 5 days. And let's assume that that is based on a Commonwealth authorization. Not really in those terms, but what if the Commonwealth Parliament passes a law giving the AFP, the Australian Federal Police, powers to, use reasonable means to interrogate individuals, and in doing so, the AFP, executive or commissioner makes a decision to sleep deprive an accused in order to elicit crucial information pertaining to a major crime that could happen in Australia. So with that particular executive decision, would that be a question of fact that cannot be reviewed by the courts, or can that involve a legal question. I give a very clear factual scenario, right? So the question really is this. Judicial review is said to be of limited scope that focuses on the process of decision-making, such as observance of fairness, procedural fairness, and natural justice, for example, and not on the decision itself. In what circumstances is judicial review said to involve a review of the decision itself, including determinations by the executive on the basis of facts? So we have an answer here from Damien. Very good. So extreme unreasonableness, or what is known as Wensbury unreasonableness, is a ground for reviewing the merits of a decision in judicial review. So that is the correct answer there. So when the executive makes a determination on the basis of the facts, so it's a factual determination, but the decision based on a factual determination of the executive is such that no reasonable authority could possibly arrive at that decision, that would then amount to Wensbury unreasonableness and can be the ground for judicial review. We're clear about that? Because in that case, that was a factual determination by the executive. But if the factual determination of an executive is so unreasonable that no reasonable authority or person could arrive at that decision, that would amount to Wensbury unreasonableness and is subject to judicial review. Another example might be, what if there is a decision by, so let's say there is a government office, and I wonder if I've asked this question before, and there is a claim that an individual employed by the Commonwealth Executive in one of the offices has perhaps committed theft. But there is no clear evidence that theft has been committed. However, there seems to be a rumor, even innuendos, that this person A is responsible for the theft because that person, is of great means. That person owns a Lamborghini or has a very nice car, and therefore possibly that person has committed theft. So therefore, in that particular factual scenario, there's an executive decision where a determination was made that on the basis of the facts, rumors, and innuendo, and the lifestyle of an individual, the executive made a decision that theft was committed by that individual, and therefore terminating the employment of an individual. The question is, with that termination, that executive decision terminating the employment of an individual from an executive department, would that be subject to judicial review? Does that involve a legal question, in other words? Or is it a purely factual question that is beyond the scope of judicial review? And in this particular case, we're not, for the moment, let's not talk of Wensbury unreasonableness, because of course they're related, but we're just looking at the evidence. There seems to be evidence. And it's often possible to rely on a lifestyle check, correct? We could agree that we could probably disagree that on the basis, but there could be an agreement that on the basis of a lifestyle check, we can make a factual determination that somebody probably has illegal wealth. What do you think? So we have an answer here. In that case, it would be beyond judicial review. What do the others think? And we're going to be examining actually this point when we look at week 7, I think. So we will examine this, but I just want to flag this early on because there's often that question about an executive factual determination involving both a question of fact and a question of law. So it's both mixed. It's a mixture of fact and law.
Is it right? Sorry, I might just be confusing things here. But if there is a misinterpretation of the facts or not sufficient evidence, probative evidence to prove something like this, that it would be considered an error of law because it's based on speculation, and that wouldn't be sufficient to evidential value to substantiate such an accusation. So therefore it would be considered an error of law, which would be then open to judicial review.
Okay, good point that you've raised, Sarah. I'd like to clarify because you raised 2 points. One was insufficiency of evidence, and the other point you said was speculation, which are not really the same. So if there is insufficiency of evidence, there is evidence, but the evidence is insufficient. Okay, in that particular case, judicial review would not be available because it is open to the executive in that particular instance to make a factual determination that can only be the subject of judicial review. So insufficient evidence means that there is evidence, but it doesn't seem to be sufficient. But evidence is there nonetheless. There's a distinction when you say that there is no evidence whatsoever. If there is an absence of evidence, for example, because the evidence is purely based on speculation, if the evidence is based purely on speculation, you can't say that the evidence is insufficient. You can actually argue that there is no evidence. How can speculation and innuendo be evidence? It can't be, even if we know that the executive is not required to use the regular rules of evidence in courts because they're not part of the court, the judicial system. But still, and so therefore, there's some liberality in the way that evidence is used. The rules of evidence are used by the executive. Still, if there is no evidence to support a factual determination by the executive, that particular executive decision can be the subject of judicial review. So on two grounds: one, when there is widespread unreasonableness in an executive decision, as far as the factual determination is concerned, and when there is an absence of evidence, then in that particular case, even though those go into the merits of the case, even though they go into a factual determination of a case, judicial review is available. And we examine this further on in the succeeding weeks. From Damien, you would think the bar for widespread unreasonableness is set so high that it follows that if a decision is found to be so unreasonable, it basically amounts to gross negligence or corrupt conduct or something that's serious by the decision maker. That could be one way of saying it, that when a decision is so unreasonable, then probably the decision maker is corrupt, or probably the decision maker has committed gross negligence, but not always. Let's assume that there is a law passed by the Commonwealth Parliament that says that again using the AFP Commissioner, giving the AFP Commissioner the discretion to determine the employment qualifications of an individual who will be employed as part of the AFP. And because of that, the AFP Commissioner, using his discretion according to statute, states that individuals who are less than 4 feet and 5 inches in height, or individuals who have tattoos on their forearms, cannot be hired as part of the AFP, or those individuals who come from Africa and who might have close relatives. Sorry, I'm not being racist here, okay? I apologize. Okay, I apologize. That wasn't the point. But if for those individuals who might be associated with, who might have relatives who belong to terrorist groups, that those individuals could no longer be hired. The question is, if the AFP Commissioner exercises his discretion in that particular way, would that be legal or not? And let's assume in that particular case, there is no corrupt conduct that motivated the Commissioner. He was doing it because he wants to get the best. He was looking at fitness. It can also be said that there is gross negligence because he was probably even talking to the lawyers. But if that is the decision of the executive, is that legal or not? Did you see my question?
I guess it would depend on how wide the discretion is set. Like if it's these sort of throwaway terms about when it's necessary and convenient, which sounds like a pretty good catch-all for just do what you want. Then I guess I take your point that it doesn't necessarily have to be like they deliberately wanted to do something. They might have just been a bit stupid or a bit naive or something about the implications of
that's true.
Impacting human rights by limiting, you've got to be over 6 foot tall to do this job or something like that.
That's right. Very good. Thank you, Damon. Very good. From Michael, that's where the entry requirements come into it. Make a wall high enough. A 4 foot 5 inch person cannot complete it. Okay. Okay, very good. So we're done with that. We've answered question 2. We've answered question. Okay, let's go to question 3. Can I get somebody to read question 3 for us? Question 3. So Damien makes a very good point from Lindsay. This raises questions again on human rights. Okay, very good. Can somebody read discussion question 3 for us? Well, Sarah, were you okay?
Yeah,
Thank you. Yes.
Claiming broad powers under the Australian National Security Act, Commonwealth, the Australia Security Intelligence Organisation, ASIO, Director General of Security, ordered the arrest and detention for a period of 90 days of Jamison Ibrahim, an Australian citizen who was alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the Federal Court of Australia for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it's authorised by the Australian National Security Act, Commonwealth, which provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat to national security. Advise on the validity of the ASIO Director General of Security's argument.
Okay. What do you think? Were the actions of the ASIO director valid or not? Can I get answers there in the chat box? Valid or invalid? Can I just get some answers in the chat box? Valid. Valid from Nicholas, valid from Damien. Okay, valid from everyone. No response. Valid from everyone. Really? You think that would be valid? You think that would be valid?
Well, I mean, I think the way that it's written so clearly, and I guess it brings the point that the Parliament passed laws, and the judiciary's job isn't to override those laws. They will, separation of powers. They will defer to the elected officials in the Parliament to, for better or worse, make the call. So if it's as clear cut as that, if it's past Parliament, then I don't think the judiciary, except for maybe a Michael Kirby type, or would be able to rule any different, even if they really wanted to.
Very interesting point. Let's extend because I had given this as an example earlier. So assuming that the Commonwealth Parliament passes a law that would authorize the AFP or the military to use torture to elicit, important information for national security, or would create a ministry for censorship, which would therefore, put a gag order even on news outlets and social media and so on. For as long as that's based on a law passed with the Commonwealth Parliament, you suppose that would be legal?
Manjo, there is a case.
Yeah.
I don't know if it's relevant in this one. It's A and Hayden number 2, which is a case that talks about where I think it was about the Melbourne case that happened in Melbourne, where the police tried to use an indemnity for its officers to do something that was illegal. And they said because the statute itself was offending constitutional rights, that the statute itself was illegal. So you can't justify something just because Parliament passes it that's against another law, because it's inherently itself illegal. So arguably in this case, the Australian National Security Act, which provides that clause, could necessarily be illegal.
That's right. So as correctly pointed out by Sarah, the case of A versus Hayden number 2, a case decided by the High Court in 1984. The Commonwealth Parliament has no authority to authorize the violation of the Constitution. And we do have a constitution in Australia, and that constitution recognizes that we are a democracy and that there are certain fundamental rights and freedoms implied in that constitution. And for that reason, the Commonwealth Parliament can never give legal authority to the executive to violate the Constitution of Australia. So in this particular instance, the courts have actually ruled, the case of Hicks versus Rudock and R versus Home Secretary, and a number of other cases which we're examining in the succeeding weeks, that when it comes, for example, to a detention of either of a citizen or even an alien, when the detention is such that it becomes punitive, it almost acts as a penalty, then only the courts actually have the power to impose such penalty. It would be a violation of the separation of judicial powers and legislative powers and executive powers if it were for the Parliament and the executive to determine how long to detain a person. But if the purpose of detention is merely to prevent, for example, a crime to be committed, and so therefore for a reasonable period of time, that would be legal. But if the detention becomes indefinite or is for a long period of time, let's say more than 10 days, that would no longer amount to just custodial detention for the purpose of safety and peace, but that would amount to a punishment and would therefore violate the laws of Australia. From Damien, we detain terror suspects without charge for a month or so right now. That hasn't been found to be unconstitutional. Okay, we'll make a distinction there, Damien. There are two distinctions there. If the terror suspect is an alien, okay, so let me repeat. If the terror suspect is an alien, then the courts have actually recognized that the executive has broader powers to continually, indefinitely detain an individual. So it's not so much because that individual happens to be a terror suspect, but simply because relying on the alien powers, the prerogative powers of the executive to control the entry of aliens into Australia, then the indefinite detention of terror suspects who happen to be aliens is constitutional and legal in Australia. Okay. Now, but if the terror suspect is an Australian citizen, it would be illegal and unconstitutional for the executive to detain that person for a period of more than 5 days. There is no ruling by any court which authorizes the detention of an Australian citizen for a period of more than 5 days without judicial warrant. You need a judicial warrant to detain a person, an Australian citizen, beyond 5 days. It is different, as we said. Yes, what's that?
What about the footballer who's been detained? He's an Australian citizen and he's been detained and risks going back somewhere in the Middle East.
Where's the football individual detained now?
I can't remember the case.
Is that in Australia?
Yeah, he has been detained for quite a long time, and I think he was arrested I don't know where he was arrested, somewhere in Asia, Thailand. I think Thailand. And they won't send him back to Australia. They're keeping him in detention, and the Australians can't bring him back.
So this footballer is actually detained in Thailand, not in Australia.
Right, but he's an Australian citizen.
He's an Australian citizen. Okay, very good point.
But they want back to his country, but he risks being killed there.
Very good.
So he's in detention for months now.
Thank you, Sarah. That's a very good point. Now, the problem, however, is that's an international law problem. Thailand can do what it likes. So if Thailand, I'm not familiar with Thai law, but if in Thailand it is legal to torture individuals, if it's legal to indefinitely detain individuals, it can be done in Thailand because their legal system is different from that in Australia. That would be an international law problem. And in international law, we know that states actually have sovereignty. They have plenary power in what is known as prescriptive jurisdiction to pass any law within its territory. It can do what it likes. And there are no limitations in international law that would limit the powers of a state to pass laws within its territory. So if Saudi Arabia authorizes torture, if Saudi Arabia authorizes the beheading of an individual who says something against the Quran, there is no recourse in international law because of the principle of sovereignty. So maybe in Thailand that is the case. In Australia, it would be different. Okay. So are we clear here? So there are limits. So in other words, the correct answer here is that I would actually advise the AGO Director General of Security that it would be illegal for him to actually detain an Australian citizen for a period of more than 5 days. Following the case of A versus Hayden number 2, a case decided by the High Court in 1984, even the Commonwealth Parliament and certainly the executive are subject to the Commonwealth Constitution, including the understanding that implicit in the Australian Commonwealth Constitution is the fact that we are a representative democracy that recognizes certain fundamental rights and freedoms, including, for example, the freedom of political communication. So the example I gave of the Commonwealth Parliament passing a ministry for censorship, that is likely to be illegal. Okay, because that would violate the implied freedom of political communication, which is recognized under the Constitution. A very good point from Mary. In the Philippines, however, do you know that since the current president, Philippine President Rodrigo Duterte has been in office, which has been about 2 years now, he has caused about 24,000 individuals to be killed on the basis alone of a suspicion that these individuals were using drugs. So drug users in the Philippines, if you happen to be poor, you will be shot and killed. It's terrible in that country. I come from that country originally. I haven't been there for the past 10 years. I haven't been back. Scary. But yes, there is now a complaint with the International Criminal Court of Justice on the basis of the Rome Statute, International Criminal Court, on the basis of the Rome Statute, that Duterte and some of his government officials have committed crimes against humanity for causing the deaths, or what is known as extrajudicial killings of drug addicts. Not just drug addicts, but even, suspected drug users. Imagine that if you're suspected of using drugs, you will get killed. Crazy country. So I'm glad I'm no longer there. But that's how it is in some legal systems. Is it legal there? Well, it hasn't been stopped with the courts in the Philippines. So presumably it seems to be something that's legal. It's a systematic activity that's going on. Question so far before we proceed to the next question? None? Okay. So we've answered this question. In discussion question 4, the question was, what does the principle of legality mean? Does it mean that every executive decision, in order to be lawful, must be supported by a specific legal authority that authorizes that decision? This was answered earlier by Sarah Rogers. And we said that only those executive decisions that can infringe common law rights and freedoms would require authorization coming from the Commonwealth Parliament. But otherwise, there are certain express and implied executive powers that would authorize the executive to undertake certain executive actions and decisions, even in the absence of authorization coming from the Commonwealth Parliament. And even then, it should be clear that simply because there is an authorization coming from the Commonwealth Parliament, it doesn't mean that any activity of the executive based on a Commonwealth Parliament authorization, meaning on the basis of an enactment or statute, it doesn't mean, therefore, that every single executive action will be lawful and valid. Because executive action and the actions and decisions of the Parliament must still be in accordance with the Commonwealth Constitution. So if the laws of the Commonwealth Parliament infringe on implied or even express rights and freedoms under the Constitution, those laws would be unconstitutional, and any actions on the part of the executive, even if based on Commonwealth statute, if they violate rights and freedoms recognized by the Constitution, they would also be unlawful, including the principle of separation of powers, which, as we said, if you're talking of a detention, of an indefinite detention of an Australian citizen on the basis of an individual probably being a terrorist, you cannot have indefinite detention, because according to the High Court, if it becomes If the detention is too long, it becomes punitive, and it is only the courts which have the power to order detention, which is a form of punishment. From Lindsay, you've lived and worked in the Philippines. I've never agreed with the death penalty, but the law is the law. Don't break it. That's right. So I think that's the funny thing, because I think they've abolished the death penalty, if I'm not mistaken, in the Philippines. So the Congress in the Philippines has actually abolished the death penalty. So courts cannot impose the death penalty, right? But policemen can impose the death penalty on their own. As I said, if they see you, if they suspect you to be a drug user, they'll shoot you on sight. There is no penalty by the courts of any death penalty, but the policemen do it all the time. To such a shocking extent, and I was extremely shocked by what happened about 2 weeks ago. The policemen there, it's now a police state, the policemen there are so powerful that they will just threaten young teenage girls, and they say, your father is a suspected drug user. I'm gonna kill him unless you come with me, to a motel. Really terrible. And there was a policeman who got caught, and the answer of the policeman was, but this is standard operating procedure. We do this all the time. Can you imagine that? So it's horrible, really horrible. So we're lucky, to be in Australia, to live where there is a framework of government, but there is just lawlessness in other countries. And the judiciary there, they're afraid of the president, because they just impeached the Chief Justice of the Philippine Supreme Court, which is the equivalent of the High Court. They impeached the Chief Justice a few months back. Really terrible. Okay.
Manjo,
yes.
Manjo,
Nicholas.
question.
Yep.
Is this the reason that so many people challenge statutes or enactments in the High Court to confirm that the statute or the enactment itself is not in breach of our Constitution, to verify that the Commonwealth actually has the right to pursue whatever it does under the laws it creates?
Yeah, that's right. Now, of course, you need legal standing for it. Okay, so somebody has to have legal standing in the sense that that person is affected by the law passed by the Commonwealth Parliament. But that does happen. They bring it before the courts for the courts to determine whether it was within the power of the Commonwealth Parliament actually to pass laws. And
yeah, I just wanted to check though. It's only the High Court in that sense that can do that, right? Like, it can't be a state court; it has to go to the High Court, doesn't it?
No, the state courts can actually pass on the constitutionality of a law passed by the Commonwealth Parliament if it has an effect on state matters. So let's say that there is a Commonwealth law and there is a state law on a particular subject, and it could be that the Commonwealth Parliament passes a law, say, on education, and there is a state law on education, and there is somebody who questions the authority of the Commonwealth Parliament to pass a law pertaining to education. Because if you examine Section 51 of the Australian Commonwealth Constitution, we will actually see that the powers of the Commonwealth Parliament are restricted in the sense that the Commonwealth Parliament only has those powers which are expressly provided in the Australian Commonwealth Constitution. Beyond that, all other powers belong to the state. So there is a demarcation between state and Commonwealth parliamentary powers. So the state parliaments actually have full authority because they inherited the colonial system in the UK. In the UK, actually, this should be clear, and also in New Zealand, the laws of the UK Parliament and the laws of the New Zealand Parliament cannot be declared unconstitutional by the courts. Let me be clear. You might be surprised. Because of the principle of parliamentary supremacy in the UK and in New Zealand, the courts passed by the UK Parliament as well as the New Zealand Parliament in New Zealand cannot be declared unconstitutional by the courts because there is no constitution in those countries. Okay? And so therefore there is the principle of parliamentary supremacy. In Australia, the states actually have parliamentary supremacy. So state courts cannot declare a state law to be invalid or unconstitutional. In general, except to the extent that that state law will violate the Commonwealth Constitution. But if it is a state law, there is parliamentary supremacy, and state courts cannot declare a state law to be invalid. However, going back to the question of Nicholas, is it just the High Court which has the power to declare a law as unconstitutional? The answer is no. Even state courts do, for as long as it might be a Commonwealth law that infringes on the powers of state parliaments. Because
so in essence, man.
Yes.
Sorry, in essence, Manjo, what you're saying is if the law itself is attributed to the states, so the state's ability to create that law under the Constitution, then it can be challenged in the state. If the law is created under the Constitution federally, but does not have any assent towards the states, then it must be challenged in the High Court.
Yeah, because that would be a federal matter. That's right. But Nicholas, I'd like to clarify that if a law was passed by a state and it's purely about the state, it will not be it cannot be challenged before a state court if it has no effect on the Commonwealth Constitution because of state parliamentary supremacy.
Yeah, no, I was aware of that. I was just checking the law from a Commonwealth standing, and then you went into the division of whether the Commonwealth's law was overriding the state law. I was well aware that the Commonwealth doesn't have that ability under the Constitution. So, but I was just clarifying as to which court and when you could go. So in some cases you can go to a state court.
Yes.
But in a majority of cases dealing solely with the Commonwealth,
yes,
it would be going to the High Court.
Yes, usually, ordinarily, it will go to the High Court, because if it's usually a Commonwealth law, because it is of such a national significance, it usually just goes to the High Court. Okay, very good. Now, final question from Lindsay. Let me just read this. I lived in a compound which was under armed guard. It happens all the time. And we had to be escorted everywhere, even now. That's true. Yeah, that's true. When I first arrived in New Zealand in 2008, I was surprised because when I went to the mall and I saw the police there in New Zealand, they did not carry firearms at that time in 2008. But it was quite common in the Philippines, and anywhere you go, you would come across security guards, you know, having firearms and armalite and heavy, you know, weapons. And all policemen always carry firearms, but not in New Zealand. I think it's happening even now. Okay, anyway. Final question. Can I get somebody to read discussion question 5 for us? Volunteer to read discussion question 5?
I'll have a go, Manjo.
Thank you. Jackson?
In order to further deter boat refugees from entering Australia's territory, the Commonwealth Minister for Home Affairs is considering authorising the Royal Australian Navy to blow up and destroy boats that are used or have been used by boat refugees. For this purpose, he is thinking of using the, I don't know what that word is. Prerogative, there we go, power of the executive to control the entry of aliens into Australia. Rule on the legality of such executive action.
Thank you. So in this particular instance, the plan of the Minister for Home Affairs is to use his prerogative power, meaning it's not based on any authorization coming from the Commonwealth Parliament. Could the Minister for Home Affairs authorize such action? From Sarah, it's illegal. What did the others think? The answer is it would be illegal. Sarah Mann is correct, and Jackson as well. It would be illegal. The Commonwealth Minister for Home Affairs, under the principle of legality, would need authorization coming from the Commonwealth Parliament, because in that particular instance, to destroy boats and blow up boats would amount to the deprivation of property of an individual, and that would therefore violate a common law right and freedom. You would need a statutory authorization for that. Okay, so that's the end of our tutorial. Any questions before we end tonight's tutorial? Questions, comments? Anything you'd like to clarify? We're good? Okay. Thank you. And thank
Just
you.
some straight up answers for the midterm would be good, Manjo, you know?
Yep. Nicholas? What was the question?
You're asking for some comments. I said just some straight up answers to the midterm assignment would be perfect. I'm sure we'd all appreciate that.
I wish I could. I could do that.
I'm saying it with tongue in cheek, Manjo, because I know you can't. It's all good.
Okay, thank you. So see you again next week, and have fun in doing your midterm assessments. Thank you and good night. Bye.